about the behavior of the boys. They thanked the ROLDF for counting them worthy for the project. The team obtained the consent of the parents of the beneficiary boys. The team followed up with sensitization training for the
Technical, let's go live. Please let us all take our seats as we are continuing with our second session of day 4. And the second session, we will be dealing with judicial updates and legislative developments, economic and cybercrime. We are looking at international best practices on economic crime investigation applicable in Nigeria. And the chairman of this session is also someone, based on his knowledge of the evidence presented in this area, is apt to superintend over this topic. There is no other person than Honorable Justice Ajile of the High Court of Kogi State. Let us give him a round of applause. My Lord will be helping us conduct the proceedings. And our lead presenter, who is an associate in the office of Solo Akuma, an associate, Chijoke Nwoye Esquire, will be giving us the lead presentation. Let us give him a round of applause. Chijoke will look forward to having your presentation. It's already in the conference brochure for those of us who have it. We also have with us the following persons to discuss Chijoke's paper. We have Chinelo Ogbozo, who is the conference director of this particular conference. Let us give her a round of applause. She has taken her time out from planning this conference to help us discuss this topic. We also have with us Benedict B. Daudu Esquire, who is also fast becoming an expert in this area and this topic. He's an associate in the office of J.B. Daudu and Co. and specializes especially in the law of cybercrime. Let's give him a round of applause. And then we have with us from the ICPC, we have a director, assets tracing, recovery, and management of the ICPC, Adedayo Kayode Esquire. Please, let's give him a round of applause. From the aspect of the security agencies we are represented, Mr. Chairman, you are well covered. And as usual, the time is stated on the face of the motion, sir. Most grateful.
Okay, good afternoon all. My Lord, the Honorable Justice Oretola, JCA, retired, distinguished panelists, and all conferees, I welcome you to this session, which I can predict already is going to be an exciting session. I have two reasons for saying that. One, we have young men and one young lady that are going to give us the meat of this session. Number two, the area of coverage also concerns an area that is still very novel, a growing area in the jurisprudence of Nigeria. I am particularly interested in seeing the contributions the panelists will make to the aspect of cybercrime, international best practices on economic crime investigation as applicable in Nigeria. There is no doubt with the introduction of the panelists I am sure we are going to have the best. And without much ado, I will just proceed to call on the lead speaker, who is Chijioke Nwoye Esquire, an associate, solid Akuna, an associate. So it's a pleasure inviting you to take your floor. Can we just give a round of applause even for him? You have 30 minutes.
Mr. Chairman, the distinguished panelists and discussants, all ladies and gentlemen present, good afternoon, everybody. May I stand on the existing protocol. The paper that I'm presenting today is on international best practices in the investigation of economic crime and the applicable practice in Nigeria. The essence and scope of today's topic is to analyze how good and bad the actors have fared within the period under review in respect of economic crime investigation, comparing the international best practices in the investigation of these financial crimes with the applicable practice in Nigeria. Generally, any criminal investigation, be it reactive or proactive investigation, is expected to be conducted within the ambit of law and in a manner that does not violate the suspect's protected constitutional rights or in total disregard to the statutory laid-down procedures. This is because the process of criminal investigation, which sometimes tends to encroach on people's protected rights, ought to be conducted within established legal framework. And if such legal framework is not in existence or if it is violated, it may negatively affect the outcome of the criminal trial of a real perpetrator of a crime. Thus, it is pertinent that all criminal investigations, including the economic crimes, should be conducted with the investigators applying international best practices that will guarantee standard investigation procedures within the realms of the law. The meaning of economic crimes. Economic crimes are usually committed in the course of performing what may look like lawful duties or legitimate transactions, but with the intent to gain undue advantage, either against an individual, a corporate body, or the government. According to the United Nations, in its 11th Congress on Crime Prevention and Criminal Justice, economic and financial crime refers to any non-violent crime that results in a financial loss, even though at times such losses may be hidden or not socially perceived as such. The United Nations in that paper went on to say that economic crimes include a broad range of illegal activities, and nevertheless the categories escape easy description. Apart from the illegal and undue advantage the perpetrators have over their victims, economic crime tend to take away the benefits of entire community, thereby leaving them with little or no developments, as these crimes adversely affect the overall economic growth and development of a country. Going by the definition of economic crime in section 46 of the Economic and Financial Crimes Commission Establishment Act 2004, economic crimes are also referred in that section as non-violent criminal and illicit activity committed with the objectives of earning wealth illegally, either individually or in a group of organized manner, thereby violating existing legislation governing the economic activities of government and its administration. There are many acts that are listed in section 46, including bribery, corruption, trafficking, and many others. Although these economic crimes are classified as non-violent, their commission may cause the indirect consequences of death or serious bodily harm. Check, for instance, a contractor who used substandard materials to construct road and offered bribe to get approval, which as a result caused multiple accidents to road users. The recent Ikoyi building collapse in Lagos may be an after effect of economic crime, with the attendant casualties still fresh in our mind. What about those who smuggle illegal arms as to be used by terrorists, bandits, or any violent group? The ones that deal on narcotic drugs, human trafficking, and related acts. These may on their faces look non-violent and legitimate, but their operations may result to serious economic damages and losses of property and lives. Although the Ufcc Act is the main legislation that is more directly related to economic crime, there are also many other legislation that touch on these serious crimes. Going by the definition of economic crimes under Section 46 of the Ufcc Act, it can be deduced that there are many provisions under the Penal Code and Criminal Code that fall within the definition of economic crime. Also, there are other legislation such as Money Laundering Act 2004, the Advanced Fee Fraud and other fraud-related offenses Act 1995, the Failed Bank Recovery Debts and Financial Malpractices in Banks Act 1994 as amended, the Bank and Financial Institution Act, BOFIA 1991, Miscellaneous Offenses Act, and also the ICPC Act. All these are legislation that have dealt with tackling economic crimes in Nigeria. Investigating economic crimes in Nigeria must be conducted in the exercise of the powers conferred on the law enforcement agencies as provided, and also within the acceptable international best practices. In this regard, some of the substantive provisions creating these crimes and also some of the provisions of the Constitution, the Evidence Act, and other relevant laws that regulate the conduct of criminal investigation, as well as any international guidelines on the conduct of criminal investigation shall be discussed. The general nature of criminal investigation. A criminal investigation, which is the first step in the administration of criminal justice, is simply the process whereby evidence are gathered to establish, firstly, if there is indeed a prima facie case of the commission of the reported crime, and secondly, if well established, to use the evidence gathered to prove beyond reasonable doubt the commission of such offense or crime, which will ground a conviction in the court of law. See the case of Core Capital Limited and another against EFCC and others. An online report on criminal investigation stated that the main objects of criminal investigation are, first, to determine if a crime has been committed, secondly, identify the perpetrator, thirdly, apprehend the perpetrator, and lastly, provide evidence to support a conviction in court. According to this report, if the first three objectives are successfully attained, then a prima facie case of the commission of a crime has been established. Several other outcomes, such as recovering stolen property, deterring individuals from engaging in criminal behaviors, and satisfying crime victims, have also been associated with the criminal investigation process. Basic investigative standards. The Global Rights Compliance, a non-governmental investigation organization that is committed to enhancing compliance with international law, particularly international humanitarian law and human rights, has developed what it called the Basic Investigative Standards for International Crimes Investigation. The non-governmental organization provides a range of minimum standards for the investigation of international crimes, which standard is basically applicable to the investigation of economic crimes. The basic international standards, according to this NGO, rely on the most widely accepted international standards in international crime investigation as employed by the International Criminal Court to increase the likelihood that relevant information is collected during such investigations in ways that perceive its potential to be useful evidence in future national or international trials. These basic investigative standards address essentially the investigative and ethical principles that should be implemented throughout an investigation. Such basic standards provide guidance on the practical steps that should be taken to ensure information is safely preserved, including how to record a chain of custody to ensure against interference, standards and procedures to be followed when collecting physical, documentary, digital, and testimonial information, and direction on how to develop a case theory. Whatever criminal investigation is carried out, any such investigation must put the legally vested rights of suspects into serious consideration. A balance, therefore, needs to be struck between the desire to establish a prima facie case of commission of a crime and preserving the constitutional rights of a suspect. The process of thorough investigation. Rod and Darrell, in their book, Introduction to Criminal Investigation, Processes, Practices, and Thinking, state that a thorough investigation is one that can identify and collect all available evidence, identify all the witnesses, victims, and possible suspects, accurately document the criminal event, accurately document the investigative actions, develop theories about the commission of the crime and the possible suspects, and finally formulate an investigative plan to form reasonable grounds to make an arrest. Rod and Darrell pointed out in their book on what they call the 3 errors of strategic investigative response, which are failing to identify and collect all available evidence and information, failing to effectively analyze the evidence and information collected to identify suspects and form reasonable ground to take action, and becoming too quickly focused on one suspect or one theory of events and ignoring evidence of other viable suspects or theories. Even though tactical investigative response is driven by urgency that requires immediate decisive action, explain Rod and Darrell, strategic investigative response is driven by the complexity of the circumstances that requires slower and deliberate approach. This makes observing the rules of law more demanding of due process and the rules of evidence more demanding to protocols for crime scene management, evidence preservation, and evidence collection. I should be jumping some of these so that I will meet up with time. Rod and Darrell stated further that once the suspect has been afforded the opportunity of speaking to a lawyer after being questioned, first of all, the suspect needs to be interviewed. If there is a reasonable ground, the suspect should be questioned. And if the ground is so formidable, then the questioning will turn to interrogation. So Darrell and Rod stated that once the suspect is given opportunity to speak to a lawyer, the caution obligation is met and the suspect may be interrogated as to his or her involvement in the crime. The administering of the caution and the opportunity of speaking to a lawyer are some of the requirements that can guarantee the admissibility of the confessional statement in a court of law. But this is not all. Rod and Darrell went on to say that interrogation usually takes place in a formal setting and often recorded, and that to avoid the challenge of the confessional statement being sustained, anything that may point to the environment to be considered as oppressive or the interrogation regarded as threatening must be avoided. According to Rod and Darrell, before any interrogation will take place by any investigating officer, the officer needs to prepare well by, first of all, reviewing the suspect's profile, criminal record, and past investigations, determine the elements of the crime, determine if sufficient evidence has already been obtained to establish a prima facie case, examine evidence that demonstrates motive, opportunity, and means, and consider, in forming reasonable ground to arrest the suspect, what physical evidence has been found that may yet be analyzed or prove the suspect's involvement with the crime. The peculiarity of investigating economic crimes. Investigation of economic crime, being non-violent crimes, may not be applicable to the earlier investigative responses discussed earlier, which are the tactical and strategic investigative responses, due to their peculiar nature. Investigation of economic crimes may be complicated because it is more often committed in the course of legitimate duties and may involve a whole lot of conspirators who may well have been involved in the crime for a long period of time before attracting suspicion, and may have devised means to conceal their criminal activities and have mastered the act of destroying or hiding their evidence. In his paper, Professor Kwok-Man-Wine described the difficulty in investigating corruption cases as follows. Corruption is regarded as one of the most difficult crimes to investigate. There is often no scene of the crime, no fingerprint, no eyewitness to follow up. It is by nature a very secretive crime and can involve just two satisfied parties. So there is no incentive to divulge the truth. Even if there are witnesses, they are often parties to the corruption themselves, hence tainted with doubtful credibility when they become prosecution witnesses in court. The offenders can be equally as professional as the investigators and know how to cover their trails. The offenders can also be very powerful and ruthless in enforcing a code of silence amongst related persons through intimidation and violence to abort any investigation. In this modern age, the sophisticated corrupt offenders will take full advantage of the loopholes in cross jurisdictions and acquire the assistance of other professionals such as lawyers, accountants, and computer experts in their clandestine operations and to help them launder their corrupt proceeds. Professor Kwok-Man-Wine listed the investigation techniques that should be known by any competent corrupt investigator as follows. The ability to identify and trace persons, companies, and properties, interview techniques, document examination, financial investigation, conducting a search and arrest operations, physical and technical surveillance, acting as undercover agents, handling informers, conducting an entrapment operation, and also witness protection. He further categorized the investigation of corruption cases, which is one of the economic crimes, into two, which can now be described as investigation regarding past corrupt offenses and investigation regarding current corruption offenses. Investigation of past corruption cases usually begins with a report of corruption which triggers the normal criminal investigation by which the report is developed to obtain direct, corroborative, and circumstantial evidence. Because the perpetrator of the crime is no longer in office, there should be a meticulous approach towards such investigation, which may include detailed checking of the related bank accounts and company ledgers, obtaining information from various witnesses and sources to corroborate any meetings or corrupt transactions. Man-Wine pointed out that the initial investigation should be covert and kept confidential, and where there is no evidence discovered in this stage, the investigation should normally be curtailed and the suspect should not be interviewed so as to protect the suspects, who are often public servants, from undue harassment. But where there is a reasonable suspicion on evidence discovered in the covert stage, the professor stated that the investigation could enter its overt stage where the suspect is interviewed, and if there is reasonable suspicion, the suspect's homes and current offices could be searched for further investigation. In investigating current corruption cases, which requires great scope of ingenuity, Kwok-Man explained that a proactive strategy is always preferred in order to catch the offender while in the act. He further stated that in appropriate cases, a proper legal order will be needed to mount surveillance and telephone interception on the suspects and any suspicious meeting monitored. There could be a development of cooperative professional to set up a meeting with a view to entrapping the suspect And an undercover operation could also be considered to infiltrate a corruption syndicate. The above investigation techniques can be applied to other economic crimes depending on whether it is a past crime, in which case the investigation is reactive, or whether it is a current offense, in which case the investigation will be proactive. International best practices in investigating economic crimes. It is believed that in the investigation of crimes, there are generally acceptable standards, practices, methods, and procedures which, in conformity with applicable laws, that are required to be observed by those who are charged with the responsibility of investigating the commission of crimes in any jurisdiction. This standard of practice and procedure also applies to the degree of skills and professionalism that this set of people are expected to employ in the course of criminal investigation globally. It has been stated that whatever system of criminal investigation is adopted by any jurisdiction, there is a universal value that must be preserved in any criminal justice system, which is the presumption of innocence until proven guilty. The United Nations Office on Drugs and Crime, in its publication, further stated that a well-developed legal framework that clearly stipulates and defines the roles and responsibilities involved in crime investigation is a prerequisite for a criminal justice system that functions properly. Rod and Darrell, in their book, also pointed out the basic legal parameters and some concepts within which criminal investigation process takes place. Top among them is the protection of fundamental rights. The United Nations, on its publication, emphasized that the regulatory framework for investigating officers operates on three main levels, which are on the structure of the investigating services, on the national criminal procedure, and on the powers available to investigators. It is noted that the structure of investigation defines who does what. The domestic criminal procedure ensures what needs to be done, while the powers conferred for investigation determines the extent an investigator can go in the course of criminal investigation. The United Nations further noted that a criminal investigating officer needs legal authorities and powers to carry out criminal investigation, and this power includes to detain a suspect, seize property as evidence, search for evidence both in premises and on persons, interview suspects, among others. In trying to consider the relationship between law and criminal investigation, the United Nations touched on the need to provide clear legal and regulatory framework which expressly confers investigative powers and the procedure for conducting such investigation, depending on the nature of the crime. These include the extent of power of search or arrest, the limit of search, if any, to persons, their property, or their premises, the procedure to obtain search or arrest warrant, among others. In the case of economic crimes, which usually require proactive investigation, using electronic means to track the perpetrator's phone calls and emails, or even to mount any electronic surveillance in offices or houses, must be backed by law. Otherwise, it becomes a breach of constitutional right to privacy. Thus, there must be put in place by law conditions that must be met by the investigating officers in order to intercept individuals' private communications, whether in the course of making calls or sending emails, or in the case of electronic surveillance. Gabriella Di Paolo, who was a senior lecturer at the Trent University, Italy, and a PhD holder in comparative criminal procedure, expressed the general global sentiment that many jurisdictions are not well equipped to handle current technological revolution and modern law enforcement. She went further to say that most electronic methods of investigations are usually unregulated by law, and that under the circumstances, it is the court that usually plays a significant role in setting down the procedural criteria that regulates technological investigations to avoid abuse. Yoon Sik Jan, a professor / senior inspector in the Department of Police Science in the Korean Republic, expressed the need to always keep in mind with the international conventional frameworks such as mutual legal assistance treaties, the Interpol, and other relevant organizations that are very useful for international investigative cooperation, considering the borderless nature of cyber crimes and also the level at which economic crime has gone global. From all that have been said, it is evident that international best practices in the investigation of economic crimes require that the law enforcement agents who are involved in the investigation of all crimes are mandated to observe the rule of law in the conduct of criminal investigation and apply all professional ethical standards so as not to violate any vested rights of the suspect in the process. Legislative developments and judicial updates in the investigation of economic crimes. Applicable provisions of the law relating to the investigation of economic crimes. There have been some legislative frameworks that one can say govern the investigation of economic crime in Nigeria. While some statutes regulate the investigation of crime generally, some others confer express powers of investigation to the relevant law enforcement agencies. The major statutes that provide the general procedural measures on how suspects under investigation should be treated are the 1999 Constitution of the Federal Republic of Nigeria as altered and the Evidence Act 2011. The 1999 Constitution talked about the rights of the dignity of human person in section 34, also in section 35, where it states the right to personal liberty. The Constitution guarantees the right of a suspect to remain silent or avoid answering any question pending when the person has consulted a lawyer or any other person of his or her choice. It is also provided in that section 35 that any person who is unlawfully arrested or detained is entitled to compensation and public apology. Unlawful arrest is always frowned at by the court as it touches on the liberty of the citizens. The court has even gone to the length of holding that the law enforcement agencies ought to conduct a preliminary investigation on every allegation of crime in order not to infringe on the fundamental rights of citizens as enshrined in the Constitution. See the case of Oku Dibia and others, and Wankwo and others. There has been the constitutional recognition of the presumption of innocence for any person under a criminal investigation, or even when such a person has been charged with an offense until proven guilty. It is very important to note the constitutional rights of suspects who are undergoing any criminal investigation to the protection of their rights to privacy, which include their homes, correspondences, telephone conversations, and telegraphic communications. Notwithstanding the protection of their citizens' rights to privacy, the Constitution made a provision where such rights can be restricted or derogated if any law has been made which is reasonably justifiable in any democratic society in the interest of defense, public safety, public order, public morality, public health, or for the purpose of protecting the rights and freedom of others. The Evidence Act 2011 have also provided certain provisions that affect the evidence obtained during the investigation of crimes, which may sometimes affect the admissibility of such evidence or the probative value the court may attach to it during trial. First to be noted is that evidence may be obtained improperly or in contravention of the law. See section 14 of the Evidence Act. But in considering whether or not to admit such evidence improperly or illegally obtained, the court takes into account the probative value of the evidence, the importance of the evidence in the proceeding, the nature of the relevant offense, the gravity of the impropriety or contravention, and whether such was deliberate or reckless, and the difficulty, if any, of obtaining the evidence without the impropriety or contravention of the law. The provision of Section 14 of the Evidence Act cannot be a leeway to improperly or illegally obtain or extract confessional statements from suspects who are under investigation for the commission of crime, even though the law has in certain conditions permitted such evidence. Thus, if a confessional statement was or may have been obtained by oppression of the person who made it, or in consequence of anything said or done that may render such statement unreliable, the court shall not admit such confessional statement in evidence. In Dundos and State, it is a 2021 case. The Supreme Court interfered with the concurrent findings of the lower courts when it discharged and acquitted the applicant after finding out that the appellant was threatened, shot at the leg, and induced into making and signing his confessional statement. The Supreme Court found that the prosecution failed woefully to dislodge the doubt the defense implanted both at the trial within trial as to the involuntariness of the confessional statement and during the defense when the defense witnesses testified avowing that the extrajudicial confession was obtained involuntarily through bloodshed when appellant was shot in the leg and through operation, inducement, and threats. It is therefore very important that the confessional statement obtained during investigation of crime must not be obtained under operation, use of force, threat, or any form of inducement. The Economic and Financial Crimes Commission Act 2004. This act mandates the Commission, the EFCC, to investigate all financial crimes, including advance fee fraud, money laundering, counterfeiting, illegal charges, among others. They are also empowered to examine and investigate all reported cases of economic and financial crimes with a view to identifying individuals, corporate bodies, or groups involved. They are also mandated to take charge of, supervise, control, and coordinate all the responsibilities, functions, and activities relating to the current investigation and prosecution of all offenses connected with or related to economic and financial crimes, and also coordinate all existing economic and financial crimes investigation. Section 7 of the EFCC Act there are so many sections that touch on investigation of economic crimes, the procedure that may be required, which I may not touch on now. Nevertheless, I will go on to the applicable practice in Nigeria. The investigation of economic crime in Nigeria has been one that is marked with mixed feelings. While it is evident that our law enforcement agencies have been in the forefront in the fight against economic crimes, more often than not, these law enforcement agencies go overboard and in the process of conducting investigation encroach on the fundamental rights of citizens. Not only this, there have been stories of bribery and corruption by the law enforcement agencies in the course of the investigation of crimes. Since these economic crimes are non-violent, it is always easy for the person suspected to have committed these crimes to buy their way out and suppress further investigation. There is a case that we are referred to, the case of 114 and EFCC. Let me go through the case. In this case, the appellant entered into a business transaction for the purchase of contracts with another, the petitioner. When the contract sale did not materialize, the petitioner petitioned to the respondent, who is the EFCC, alleging that he was cheated and sought the assistance of the respondent to recover this money. The respondent invited the appellant and after his preliminary investigation, arrested and detained the appellant, but later granted him bail. But because the appellant could not meet his bail condition, he was released on bail the following day. The appellant later filed an application to enforce his fundamental human rights, which, after considering the facts and evidence, the trial court dismissed the application for lacking merit. The appellant appealed to the Court of Appeal, which, after reviewing the proceedings at the trial court, also dismissed the appeal. But while delivering its judgment, the Court of Appeal held entirely as follows: that the respondent is by law entitled to investigate and prosecute the offense of forgery, obtaining under false pretense, and issuance of dot check. The respondent has the power to arrest a person under reasonable suspicion of his having committed a crime, or to prevent him from committing one, or where an officer of the law enforcement agency reasonably believes that such a person has committed a crime. However, the discretionary powers of the respondent, that is the Ufcc, to arrest and detain a citizen is neither left at large nor a carte blanche for indiscriminate and unwarranted arrest and detention of the citizen without any reasonable grounds as provided by Section 35 of the Constitution. The respondent is not saddled with the authority to interfere with and meddle into disputes of purely civil nature between citizens in contracts of which the law courts are best suited and appropriate. The appellant has no immunity in law from being investigated for allegation of committing any criminal offense, and his right to personal liberty was therefore not breached or threatened or likely to be breached merely by reason of his invitation, arrest, and investigation for the criminal offense. It cannot be said that the respondent had detained the appellant for a period longer than that which the Constitution stipulates, as the right to personal liberty is not absolute. And finally, the court is under a duty to protect the citizens from the brazen breach of their fundamental rights and from unwarranted and unconstitutional interferences by the law enforcement agencies. The case of Wafo and EFCC no doubt summarizes the investigative powers of the EFCC, the challenges of abuse faced by the citizens, and the resolve of the judiciary to ensure that while it will not interfere in the exercise of the functions of law enforcement agencies in their investigation, prevention, and prosecution of crime, it will not permit the law enforcement agencies to trample on the rights of individuals when performing their statutory functions. Conclusion. It is very important that in our fight against economic crimes, all investigations to be conducted in order to establish a prima facie case of the crime need to be done in the most appropriate way and in line with the international best practices. These include the observation of the laws as it relates to the rights of citizens, even when under criminal investigation. The violation of rights in any way whatsoever, the obtaining of evidence by threats, oppression, and inducement must be avoided, and the abuse of the investigative powers of the law enforcement agencies to recover debts for individuals with a view of getting commission therefrom should be frowned at. There is the need to have a laid-down procedure, either in the form of legislation, manual, or guide, that will direct the law enforcement agents in the manner in which investigations should be carried out. Some countries have investigation manual and guidelines. I am of the view that such will help improve the qualities of investigations by our law enforcement agencies. Thank you.
Well, we thank Mr. Chijioke Nwoye for this powerful lecture, ably delivered, on international best practices in the investigation of economic crimes, applicable practice in Nigeria. You will agree with me that he has done justice to this topic. His paper covers a wide range of issues, commencing with the meaning of economic crimes, the definition of a crime, the applicable laws in Nigeria on economic crimes, the general nature of criminal investigation, the process of thorough investigation, the peculiarity of investigation of economic crimes, and the techniques of investigating economic crimes using corruption cases as yardsticks. He also went into international best practices of investigating economic crimes, emphasizing what he describes as a universal value that must be preserved of course, which is not strange to our law, presumption of innocence until somebody is proven guilty. Then he looks into the Nigerian experience, provisions relating to investigation, citing so many examples of statutes, the Constitution, the Evidence Act, the Ufcc Act, and the applicable practices. So he has actually covered the field sufficiently, effectively, and elaborately. So I want to invite you to give another round of applause for a well-delivered paper. Mr. Chijioke, thank you very much. We proceed straight away by inviting our beloved sister. It's already on her feet. Chinelo Ogbuzo Esquire, an associate, JB Daudu and Co., and director of what do we call it? The Annual Criminal Law Review Conference. She's the director. And let's give her a round of applause.
Thank you, Mr. Chairman. Please, I beg to stand on existing protocols. I will say that the lead presenter has said everything. And if I'm permitted, I will just say that I adopt. I concur. And then I take my seat. But woe betide a lawyer that is asked to say something and doesn't say anything. For my Lord may put me on duty to adumbrate my own brief. I want to touch on 4 issues very briefly. My paper is not yet ready. I will submit it in due time. The system of investigation through the process of invitation. That is number 1. Second one is invasion of privacy by law enforcement agencies. The third one is on detention orders, which also relates to the fourth one, which is the role of magistrate courts in investigation of economic crimes in Nigeria. On the system of investigation by invitation, there seems to be a trend where, especially the Ufcc, they will write you a letter inviting you, saying we're investigating a petition XYZ that involves you. You should come to aid investigation to answer a few questions. The moment you receive that letter, you know you are under arrest. And that is not the proper approach. There is investigation and there is an arrest. So you wake up in the morning, dress up from your house, walk into the Ufcc, and you are walking out on bail. Without anybody telling you that you are a suspect. You are told to come on invitation to aid the investigation of the agency. And you walk in, and automatically you are a suspect. You are looking for a director in an agency or somewhere that will sign a bail bond for you to leave the Ufcc office. Recently, the former minister of the aviation, Fani Kayode, was fighting with his perceived enemies on the internet, saying he was not arrested by the Ufcc. They just invited him for a chit chat, spent 8 hours, and then he left. He was granted bail. And it was funny, but it was not funny, because he sees it as an invitation, and then at the end of the day, he's saying he was granted bail. So I think something has to be done, either by legislation or the courts may have to step in when the case arises. That is, either you have concluded your investigation, and at the point where you are inviting this person, you are putting the person on notice that you are already a suspect, which is supposed to be the proper procedure. Not that you are doing information gathering, and at that point, you are also doing interrogation. That is number 1. Then number 2 is on the invasion of privacy. Now, on the 29th of October 2021, somewhere late in the evening, we all received information that some law enforcement agents had invaded the home of a sitting Supreme Court justice. And they said they were investigating, that they said they saw money, that somebody said there's money, huge amounts of money in the house of the judge, the justice. And what interested me the most in that case was the court order that was used for that purpose. And this is where I think the magistrates court system in Nigeria has indicted itself, and this has provided us an opportunity, which I think we are about to miss, to fix that system. You look on the face of that order, the applicant is called Joint Panel Recovery Ministry of Justice. Respondent, House number 9, Imo Close, Maitama, Abuja. The average law graduate looking at that process knows that there is a problem. The two parties are non-juristic persons. So you begin to ask yourself, how on earth did this process go through a judicial arm of government and somebody got an order to have the temerity to invade the home of a sitting justice of the Supreme Court of Nigeria? The magistrate who made this order is a lawyer by profession. By the mere fact that you are seeing Joint Panel Recovery Ministry of Justice, you should know that something is wrong. And that order should never have happened. And if that order never happened, the incidents of that night would never have happened. And this is where we should be focusing our attention on. Not on whether the man is a fake, he's an original, he came from whatever, he's a contractor with who or not. If we ensure that the gatekeepers, which is the judiciary, are doing exactly what they are supposed to do, which is why they are there, all these incidents of overreaching actions of law enforcement agencies and authorities will not happen. We have seen it. They get court orders to invade hotel rooms, to invade an entire estate. These orders are granted as a matter of course. It should not be happening. There should be intelligence gathering before an order is given. Somebody should not walk into a courtroom with a vague affidavit saying, I believe there is criminal activity going on in estate XYZ, therefore give me an order. You should have a house number. You should have the name of a suspect or a description of who you think you are looking for. Because another danger is that we are opening up ourselves to criminality. We know the level of kidnapping in Nigeria now. It does not take away anything from criminal elements to gather themselves, sew up uniform, take a bus, arrive into an estate and say, oh, we are from Ufcc. And then they start breaking down doors. They carry your laptop, take your... In fact, as a matter of fact, the Yahoo boys can actually do that. Get into your house, carry your bank cards, go out, and then you'll be receiving debit alerts. You will say it's EFCC, and it was not EFCC that came to your house. Then when you sue, the EFCC will say, it wasn't me. So who do we hold responsible at that point in time? I think that these are some of the issues. When we talk about the best international practices, this is not obtainable in jurisdictions where the judiciary at that level do their job. You cannot investigate and search an entire estate. If you have to search the building in an entire estate because you are looking for a one or two persons, you have not done intelligence gathering. And my conclusion is that you should not be given a court order. You should be able to show that you have done some intelligence gathering and that there is something left to be done, that if this court order is not granted, you cannot conclude that investigation. You don't wake up, enter your bus, and then go and start arresting people, breaking people's doors. That is how criminals operate. Law enforcement agencies should not operate the way criminals operate, except the need, highly demands of it. Now, going to detention orders. The lead presenter has mentioned Section 35 of the 1999 Constitution on the freedom, rights to liberty of persons. I will say that law enforcement agencies now consider that provision a joke. Because the moment you are arrested, if they don't want to release you, they will just tell you we have a detention order. The little they can do is just take you before a magistrate court and say they want to detain you. And you hear ridiculous orders for 40 days. Freeze account for 90 days. Freeze this one for 160 days. How do you want to detain somebody for 40 days and expect that the person will exercise the right to silence? By so doing, you have defeated that right. You have defeated the presumption of innocence, and the person will give confessional statement. Who wants to stay in EFCC detention facility for 40 days? You will sit down and say, okay, even if you didn't do it, you must say something so that you can be released. So by giving ridiculous detention orders, we have eroded the right to silence. And by so doing, we have defeated the express letters and the spirit of the Constitution. Now, on Dondos again and the state, that authority was already discussed on Monday and Tuesday extensively. Now, you look at that authority and you find that the Supreme Court was very angry that somebody was shot and all of that happened, and the lower courts did not do anything about it. And the Supreme Court went ahead to order that the police officers who were involved should be investigated. Now the question is, what happens when there is no bullet wound? What happens when you are just detained and kept there? You are being tortured. You don't have to be beaten. The fact that you have been deprived, some people go into detention, they have to take their medication and do a lot of things. People are told, okay, admit that you did it and we will not prosecute you. When you come to court and you are telling the court that this was what happened to me, will the court really believe you? Will the Supreme Court believe that having been detained for 40 days, you actually, they breached your right to silence because you had to volunteer a statement so that they can leave you to go home? What happens at that point in time? It still takes me back to the incident of 29th October 2021 to say that all the actors, especially the judiciary, the people who were involved from the court system, must be punished. Discussions have been had. People have said this is going just to the lower fish when there is the big fish. The lower fish is who is needed the most by the big fish to operate. If we go for the lower fish, the big fish will have to find an alternative means. And while they are finding it, at least we will be having some breather. Then I go further to Section 14 of the Evidence Act. How many times have the court really rejected evidence because there was a breach of rights? In how many situations and how many occasions? Now we have a system where we say that we are trying to help the government to fight corruption. So we are bending over backwards. But what we have is that the more we relax the rules, the more there is non-compliance with even the overly relaxed rules. Therefore, if we are going to not apply Section 14 to the extent that evidence that is obtained by the tiniest of infraction is thrown out, we should at least look at a situation where we make it a mandatory provision that a lawyer must be present before you take the statement of an accused or a suspect. And the failure to have a lawyer present prima facie knocks off that evidence, that confessional statement or extrajudicial statement. Let us put it in our law. The law enforcement authorities will say that will make their jobs difficult, but let us put it there. Let us start from somewhere. It will ensure to some extent that the right things are being done. If you have to arrest somebody who has no capacity to hire a lawyer, there is the Legal Aid Council. We can also go to the NBA and find a way to assist people in that category. But let us make it a mandatory provision of the law that any extrajudicial statement made in the absence of a legal practitioner will not be admitted in evidence. So that it does not become the norm of people coming to court to say, they beat me, they threatened me, they did this and they did that. We know that these things happen. We know that these things happen in detention. But let us ensure that the rest of the people, because not every defendant has the capacity to afford a lawyer that will argue his case to the Supreme Court. Dundos was fortunate. Dundos had a lawyer that fought up to Supreme Court. Many do not have that financial capacity to do that. It is those kind of laws that will protect and checkmate for the common man whose judicial determination of his rights may start and end at the magistrate court level. Then furthermore is the section 35(4). I will say that the way we grant detention orders, it's as if section 35(4) does not exist in our constitution. That is the section that states that any person who is arrested in accordance with subsection 35(1)(c), which deals with detention on suspicion of crime or that you are about to commit more crime, shall be brought before a court of law within a reasonable time. The law went further to say 24 hours where there is a court nearby, and then for capital offenses there is also a provision. It is this provision that law enforcement agencies use to take you to court when they feel, okay, your lawyer is going to probably come next and file fundamental human rights enforcement action. So they go to court and then they are given detention orders. I do not believe that the spirit of section 35 is just for the purpose of bringing someone before a court of law. I believe that this provision means you should be brought before a court of law for immediate commencement of your trial. It is not enough to bring the person before a court of law. And that is what law enforcement agents are doing. That's okay, 24 hours, okay, we've brought him before a court. Your worship or your honor, we are still doing investigation. Give us detention order. Then you give someone a detention order to hold another person for 48 days. The magistrate that is granting that order, if an order is granted to hold that magistrate for 48 days, will he still have a job by the time he comes out? If you are running a business and you are detained for 48 days, will you still have customers when you come out? If you are detained for 48 days as a lawyer, will you still have your clients when you come out of detention? Of course, that is enough for you to go in and offer voluntary statements, admitting whatever you can admit. In fact, they can write anything for you, you sign and say, okay, when I get to court, I will challenge it. And by the time you get to court and you are challenging it, the judge was not there. And the judge will look at you and say, well, you volunteered statement. You volunteered statement within 2 days. And the judge will admit it, and that is how you end up in prison. So we have to do things in a manner that ensures that the lower court is put in check and given guidelines on how to operate. The opportunity has provided itself, and I hope that we take that opportunity. And this brings me to the final point of appealing to the authorities at the Federal Ministry of Justice, especially to the Office of the Attorney General of the Federation, to say that the Office of the Attorney General of the Federation is an authority that protects the people. That is an authority that should supervise the acts and activities of law enforcement agencies. It is therefore ugly that we are in a situation where people are pointing accusing fingers at the office, saying it's the office that ordered an invasion. It is not a good look on us, and I believe that the conference, when we are compiling the communique, these are some of the issues that should be put into our documents and our papers to also encourage the NBA to be actively involved in the next political dispensation to ensure that only credible authority and persons get into office as Attorney General or Minister of Justice. Some people have said that the office should be split. Whichever way, whichever one will work, we should ensure that only people of credible character who will also act as gatekeepers of justice in Nigeria should get into that office. I thank you for the opportunity.
That was a very beautiful intervention from Chinelo, who came to speak almost like a radical. I think she's one anyway. So please join me in giving another round of applause for her. She covers, well, as a backup to the main paper areas. She identifies as a system of investigation, invasion of privacy, and detention orders. And she comes up with a practical example, live cases, and most recent of those cases. The practice of invitation by Ufcc and this Fani Kayode's case, who went there and came out pretending that he was not arrested. But I think it would have been a better thing. We would have understood him properly if he had come out to say, yes, I got that invitation and I went there, and it was an invitation to attend a dinner. And we had a wonderful time that night. Yeah, you know. But to come out to say that you were granted bail, of course, any lawyer will know that something had transpired. Anyway, Chinelo has said it is not a good practice to just write somebody, and from there he finds himself in detention. Invasion of privacy. She actually puts a lot of blame on the magistrate who signed that search warrant, which is an indictment on our judicial system. And well, speaking from experience, so many of such things happen. You know, the way she analyzed it, the complainant, non-juristic person, the defendant, as it appears on that paper, the defendant, a name of an address of a house, and of course the offense, an illegal activity going on. I mean, from any aspect, there should really be no reasonable magistrate who should have gotten that order and will proceed to, you know, to append a signature on it. Well, we are waiting for what will happen, but I think we must get to a point where somebody must be made a scapegoat. Detention or the invitation, detention orders. Well, she also covers areas of investigation and arrest, Section 14 of the Evidence Act, Section 35 of the Constitution, and also made a final appeal to the office of the AG, and recommending very strongly that only a man of character should occupy that position. And I agree with her. But I think a process is going on. We hope it will come up, it will snowball into a concrete effort from the National Assembly, where the office of the Attorney General will be severed from the office of the Minister of Justice. I think that is one problem that we have to identify here. As long as the Attorney General remains a politician and knows a duty to his appointee, his principal, the president. The president was elected as a politician, and there is no way. Sometimes we will not find some conflicts of interest in that office. So maybe, hopefully, if the amendment says true, that in the nearest future we have the office severed, Attorney General and Minister for Justice. And maybe that will take us to a better position. So please, you will not be tired as I call you again. So please give another round of applause for Chinelo. And on this note, I will just invite Mr. Benedict Daudu. He's also of the Daudu, KB Daudu and Co, an associate, to take his floor. Thank you very much.
Thank you very much, Mr. Chairman. Distinguished panel, allow me to stand on existing protocols. And also at this point, hint that after this session, I would be going to Mr. Chijoke for an autograph, because he's very commendable in the way he has actually analyzed almost the whole issues in criminal investigations. Now, the topic I'll be speaking on is economic crimes, international best practices on criminal investigation. Criminal investigation is a multifaceted problem-solving challenge. Arriving at the scene of a crime, an officer is often required to rapidly make critical decisions and sometimes involving life and death based on a limited information in a dynamic environment of active and still revolving events. After a criminal event is over, the investigator is expected to preserve the crime scene, collect the evidence, and devise an investigative plan that will lead to forming of reasonable grounds to identify and arrest the person or persons responsible for the crime. To meet these challenges, police investigators, through training and experience, learn investigative processes to develop investigative plans and prioritize responses. Now, what is crucial in the realm of criminal investigation is the priority of responses, and we'll see that in the course of this paper. Now, the craft of criminal investigation has been evolving since the birth of modern-day policing in the mid-1700s, when the chief magistrate of Bow Street, Henry Fielding, organized a group of volunteers in plainclothes citizens and tasked them to attend the scenes of criminal events and investigate those crimes. This group became known as the Bow Street Runners. Their existence speaks to an early recognition that attending a crime scene to gather information was a timely and effective measure to discover the truth of what happened. So, as earlier posited by my lead speaker, the main objectives of criminal investigation are to determine that a crime has been committed, to identify the perpetrators, apprehend the perpetrators, and I must take a shift from what you said. It is also to provide relevant evidence to assist in bringing justice, not only to help secure a conviction. So we must depart from that perspective that it is only solely for the prosecution, but justice at large. When criminal investigations are ongoing, it is of grave importance to ensure that the vested rights of suspects are considered. In the realm of cybercrime, which luckily is my area, the rapid development of information technology and communication has changed the trend and practice of criminal investigation. This has created an enormous challenge for law enforcement to develop capacity to confront transnational crime and follow the trails of evidence. And our example would be the not so recent arrest of Ramon Abbas, aka Hush Puppy. Hush, as I fondly call him, who is currently facing criminal charges in the United States for conspiracy to launder money obtained from business, email compromise fraud, and other scams, including a scheme that defrauded a U.S. law firm of $40 million. His arrest was one that was carefully orchestrated through the efforts of the FBI and the Dubai police force. So we see that there is a there's a shift from just doing things on your own, but there's a need for mutual cooperation between various jurisdictions so as to provide a clearer way to investigate criminal offenses. But going back to criminal investigation in the general form, it is a device for justice to be carried out by the machinery of justice, like the Ufcc and the police force, that should be carried out within the ambits of the rule of law. There are international standards in place, as earlier elucidated by Mr. Chijoke and my colleague Mrs. Chinelo, as well as other domestic safeguards in form of Section 34 and 35 of the 1999 Constitution of the Federal Republic of Nigeria. Now, the hard-hitting question is that are the derelict and consciously deficient methods of policing and investigation in Nigeria ever to evolve to a hive pursuit of justice in its truest form? My answer probably will be answered by the audience and various discussants. But I must draw our attention to instances like NSAS protest, instances that show that there's an intrinsic bias that is fettered on the youth. There's intrinsic bias that is fettered on young women who may choose to dress as they choose. And because of that, it may hinder the investigator's perspective on whatever investigation that they are pursuing. Now, this is where the judiciary is looked upon to properly interpret the ill-gotten fruits of criminal investigation so as to crystallize that inalienable right that are given to suspects. Thus, we see cases like Oketiboa, where the court held that the mere fact that an allegation is made against a person does not justify an arrest or detention. In other jurisdictions like the United States, we have the Fourth Amendment, which provides the right of people to be secure in their persons, houses, papers, and effects against unreasonable search and seizures without a warrant, if I may add. And then it is only possible where there is a warrant that is actually specific to and gives the particular places to be searched, not just a blanket check. Whilst the Ufcc has broadened the powers of criminal investigation and prevention of economic crime, these powers are to fall within the ambit of the Constitution. The Ufcc has the power to arrest a person upon reasonable suspicion of his having committed a criminal offense, but there is a reasonable standard that is there, and that is an objective one, as stated in Obolo and COP and Obolo. Now, looking at the Evidence Act, Section 14 has generally been used as a leeway, as my colleague said, to improperly or to illegally obtain confession statements from suspects. The simple truth is that in most cases, there is no probative value. In all the above, we must commend our law enforcement agencies for being at the front line for domestic and international criminal investigations. But we must say that what is worth doing well So we must ensure that there are guidelines in place that train and update law enforcement on the rights and liberties as recognized by international community and the Constitution and the courts. Now, I will just list a few problems that emerge towards criminal investigation in accordance with the rule of law. One of them is proper funding. Criminal investigation is not a cheap matter. It requires money and it requires training of those who are capable and adequate to yield proper results. When you report a crime in Nigeria, the practice is that you go to a complaint desk and then you lay out your complaint and you're asked to bring money to open your file. You also, as the same complainant, you are also the same person that will provide money for fuel if they can't get to the location to investigate. I need to state that I don't need to state every instance of underfunding But what is clear is that underfunding is an attribute of the failures of criminal investigation in Nigeria. Now, another issue when it comes to criminal investigation is corruption. Although I would let the discussants also update us on that, I'll just list it. Another issue is digitization of case files. Another issue would be the lack of forensic labs or poor record keeping. Now, in conclusion, Nigerian criminal administration of justice system is plagued by a host of challenges, amongst which are poor and ineffective criminal investigations. It is vastly important for criminal investigation to adhere to the rule of law. There is a need to educate law enforcement agents, a need for the legislature to pass codified rules of engagement when carrying out criminal investigation, and a need for judges to not bend backwards when they face result-oriented or predestined cases. That's the cases where the executive want a result and they want the judges to bend backwards. So this is to protect the presumption of innocence and find inadmissible evidence when they are prevalent and have tainted the prosecution's case. Thank you very much.
Thank you very much, Benedict, for this contribution. Well, you have looked at the system of criminal justice generally, and in particular reference to investigation. Investigation, no doubt, is a critical stage in any criminal justice system. You have identified the objectives of investigation, the need to apply best practices, and the basic or the core issue there is compliance with the rule of law. You mentioned the guidelines, you mentioned the problems associated with investigation, some of which are improper funding to trade personnel and even to make logistics available. This one brings me to reminds me of a recent incident where somebody stood as a surety for another person, not in a crime, but it was in a business transaction. And he gave out his papers to stand as collaterals. At the end of the day, the man who was involved in the contract himself did not supply what he was supposed to supply, and the man who stood surety for him was arrested. And it was said until he made available, of course, the man who was engaged in the contract. Ultimately, for the man to be arrested, this surety who was in police detention told me how much he paid to the police in the process of looking for the principal actor. In other words, like Benedict has said, no funds were made available to the police to do the job. It was him now who made the money available to look around to get the defender. Eventually, he was gotten. So there is no doubt we have all these problems. The education of the personnel and so many other things, digitization, need for it. We have poor records anyway. And, he did not leave out the judiciary too. The judges are rule what we should do. Thank you very much for all that you have done. We have said. Now the last but not the least to be invited to give us his own perspective within 10 minutes is no other person than a person who is a director, access tracing, recovery and management of the ICPC, Mr. Adedayo Kayode. Let's welcome him to the podium. Second, you are welcome. Let me take that again. The chairman, my lord here seated, distinguished panelists, ladies and gentlemen. Everybody who has spoken earlier are speaking from the private practice perspective, and I think I'm going to have an honor to speak as a practitioner, and that's beautiful. But let me first state it that for those of us who are privileged to be in the law enforcement side now, we also see ourselves that we can be on the other side. And there's we have practical examples to show for that. Tafa Balogun was investigated in this country and arrested. The former IG. ICPC prosecuted Sunday Indero, the former IG. Ibrahim Magu was investigated in this same country very recently, the former chairman of Ufcc. So even me that is standing to be a victim tomorrow, or whichever way you want to call it. So even while we are doing our job, we are conscious of the fact that we may not remain on that side forever. So what you feel and what you go through, we actually feel and we go through it. I'm divided between two now to clearly present what I have. And I also feel strongly tempted to be able to put some clarity out or some of the things said by my friend and colleague. Chijoke has spoken, Chinelu has spoken, Benedict has spoken. And there are one or two things that I feel that we need to really get clear. But one most important thing that I would not want us to leave this place without getting clear is corruption, which is the bedrock of everything we are discussing here this afternoon. And the first thing that we need to get to understand is this. What does the word corruption mean? The clarity that I want us to go home is this. People describe corruption in different ways and we all have different pictures for corruption. But we have come to simplify that. UN define it as an abuse of office. But to make it very clear, I want you to see this afternoon that corruption is abuse of three things. Abuse of policy, abuse of process, abuse of procedure. Once you abuse laid down policies, there must be an intent. If you have to go ahead and abuse laid down processes for getting things done, there must be an intent for you to abuse it. If procedures will have to be abused, there must be an intent. So corruption sums up as an abuse of entrusted power for a personal gain. And that is the reason why people abuse these three things. We must really understand that when we talk about law enforcement agencies, there is this temptation to carpet everybody. But more often than not, that carpeting is not always saying the truth, or is not standing on a just cause. I joined the ICPC about 15 years ago, and I remember that one of the first things that I told the people who had to work with me is this. We cannot continue to follow the police model of investigation. The police model of investigation says who first reported holds the case. But real investigation is not that. Real investigation is an objective and an empirical analysis of all available evidence to draw a conclusion. So we had to change that pattern. I'm going to cite two examples here from practical experience. I'm telling you a story of what happened about 8 years ago. A woman who later became a permanent secretary and a retired federal PAPSEC in this country was then a DFA, and she had to appear before me. And by the time we were through the process of the interview session, the first question she asked is, "Excuse me, sir, what is your profession?" And I told her, I said, "Hey, I've been here before. I know the way the police does it." This is not an attempt to castigate the police, but it's just to let us know. Most of our police rose through the rank. But it's different from when you bring different professionals at different levels and you get them into the act of investigation. These laid down principles and techniques of investigation becomes very easy to follow. I also had another one in which a former governor in the
northwestern part of the country had a case with the commission. And he wrote a letter to the chairman of the commission that he wants to bring in 6 firms of chartered accountants to investigate along with the commission. Of course, that is not their job. And I guess with the pressure that comes from him, the chairman invited me. Then I was heading the financial intelligence unit. And the chairman invited me. Kayode, this is what this man is saying. I said, sir, please let them come for transparency's sake. Sometimes you've got to go to the river and let everybody splash water unless they will get drowned. So let them come in. And I told the principal, I said the same knowledge that this chartered accounting firm are going to bring in is what we also have in the commission. Bring them in. And we worked together for about 3 months. I created a special role where we were working. Midway into the 3 months, these people came and say, hey, is this the way you people work here? That was the first reality that dawned on them. The second reality was that they were in as agents of that former governor. But by the time we were done with the investigation, even the witnesses that they have arranged on their side were the people that we found culpable, and we charged them appropriately. And on that case, we got conviction. And for us to be bold to charge the witnesses that they had come to align, it was all the facts were clear. We examined it together. Till today, this managing partner of this firm are friends of the commission today because they saw our work in a different light. So we're talking now that when we get to practical investigation, all our agencies have practical way that are listed that we know and procedure that we follow for investigation. One thing that has not also been dropped appropriately on the table here this afternoon as we're discussing is we have not discussed extensively on the issue of recovery of assets, which is highly germane now and is a cry of the whole world. And we have not talked about illicit financial flow, which has to do with illicit sources, illicit transport, illicit movement, and illicit usage. We talk about economic crime, we talk about financial crime, we talk about money laundering. And the whole thing about money laundering is that we must be able to look at the fact that there must be an establishment and a proof of the predicate offense that leads to the money laundering. I want to particularly challenge Chinelo, Chijoke, and Benedict that my 3 co-speakers have forgotten to recognize that the ICPC Act was enacted in the year 2000. In fact, that's the first bill that was enacted in this democratic dispensation, and was enacted basically to fight corruption. Every other act that comes in the respect came after that, and that's to let you know that the ICPC has been existing for about 21 years now, and the FCC also about 18 years. And I think one of the reasons that I've been able to let us go on to have the EFCC is that at the craft of the law, at the enactment of the ICPC Act, focus on public institutions because it defined public officer and defined public institutions. Meaning that this act must have either been perpetrated by a public officer or perpetrated by a private person in conjunction or dealing with a public office. But by the time we have the financial and economic act, we were looking at various other decrees that are still necessary that has not been taken care of and packed together. So we must understand that even the economy and financial crime is also corruption. I also need to let us know here that my brother Chijuke was talking about the fact that corruption at times could be so difficult to perceive or to really be investigated because you could have satisfied 2 parties. And I agree with you absolutely, because most of the petition that we receive at the commission is not petitioned from patriotic point of view. It is because there's an aggrieved party. It's only come around when the sharing formula is not right. When Chijuke and I are engaged in an act, and then in the course of sharing, the formula does not favor me. And that is why you see in most cases people will write petition to ICPC, to EFCC, to civil defense, to police, to Boy Scout, to Boys Brigade, to virtually everybody that needs to be written to, and just throw in the web and see who picks it up. Now, this is what we have to contend with. So much emphasis on money laundering, but I think we also need to start talking about the predicate offenses and places emphasis on them so that we can push down the frontier of our understanding and perception of these things. And I must state here that all our agencies have investigation manuals. I want to state that very clearly. So even all the procedures and all that you have listed, we have investigation manual. And like I even want to tell you that even asset recovery, there is an emerging field now. In ICPC, we already have an asset recovery and management manual, approved, printed, and that can be shared. Chinelo apparently sat directly opposite me, so by the time she was done speaking, I became very uncomfortable looking at her face. But I must tell you, my sister, we obey the judge's rule that says that we must caution. So one thing that we have been able to do in our processes is that we have been able to make a clear distinction between when we are bringing somebody in as a respondent, we don't use the word suspect anymore, or bringing him in as a witness. When we perceive that he's coming to help us to shed light on this investigation, we don't caution, because we already have it at the back of our mind as part of our strategy, which is embedded in our tactics and procedure. We already have it at the back of our mind that that person is going to assist us in the course of investigation. So we ask you questions freely, and then you make statement. But when we believe that this person is already in the strategy and in the covert or background digging and investigation we have done, is going to be responding to questions, we caution you have been issued, and it's in obedience of the judge's rule. So when we've cautioned you, then it behoves on you to be able to go out getting somebody to bail you. And I must say here that when we send these letters of invitation out, we had always put it there: please come in with your lawyer, please come in with a justice of peace, or please come in with, you will state there that you have this right, come in with these people. And you know, the Act make very clear provisions these days. Your lawyer is seated by you. We ensure your lawyer is seated by you. You can confer with your lawyer. So all this, we have really outgrown this in our operations. And when we talk about court orders to arrest or conduct searches, it's a pity that I sat here and I feel strongly carpeted for what we do not know about. Yeah, we the law enforcement officers, honestly speaking, receive this bash. But I want to tell you, I believe very strongly this was just highly political. And like his lordship just said, some of the thing is just that we said that will just be the beginning of the solution, but that's not the final solution. Because you asked me today, why do palm sex always walk their hands up as if they are praying to God when they are before the honorable ministers? So when you still have an attorney general who still sub to the federal minister of justice, man, say have a repeat of this. But I just think, like Chinelo said, we will be praying. Let NBA come together and also do a lot of social engineering, and let's begin to see that we have people who will go there and represent us. I didn't say any particular office. All right. And then whistleblowers, and you talked about still going back to that court order. Since some years ago, when we came out with that whistleblower policy, there has been lots of abuse. I have asked to also grapple with that. In fact, I want to cite for you here about two or three examples. There was a day somebody just would say, oh, I know of a particular house in Kaduna, they just moved $1 there overnight. And when they write such to you and you do not do anything, these are the people who go back to the press and go back to the public and, you know, just destroy the name of your organizations. We don't know what they are doing there. They are just collecting salary for nothing. They are not effective. They are not this. They are not this. So, and then sometimes when you also send some people out to do this covert operation and do the observation and finding out, in fact, the way the whistleblower will come on you, actually, you will want to believe that he has all his evidences. But when we send people there, we discover that almost 4 different law enforcement agencies has received the same information and go to the same place. And absolutely nothing there. There was even a particular case that some brought some information and said that there's a particular place in Lagos. But there was a funny thing about that. When the man came, I'm sorry, Chairman, can I still speak on? And then when he came, he says, but you know what? You know what? That man, he has juju. So when your people come, we will give them the juju. They will enter the house. They will say, you will give a law enforcement officer juju to enter into a house. Is that part of my mandate? And these are some of the things that we have to contend with. We have one we are dealing with presently, like somebody just wrote and said in a particular area in Abuja, there are 3 properties, and he listed the address of those properties, and those properties are abandoned. So it must have been from corrupt practices and everything. And he tried to link to somebody. And you go in there and you despise all force. It's just this craze that everybody wants to have something to collect. Maybe if they go in and they find something, then I can get my own whistleblower's reward. And that has also caused another problem of its own. But then, there's the good side of the whistleblower policy. So we can't jettison it. Because it's also fetching us some credible information that are leading to very successful investigations. And when we talk about rejection of evidences in breach of procedure, I tell you, it happens. ICPC lost a case very recently, and all that made us lose it was just that the judge just asked. In the interview room was his lawyer present. Apparently the lawyer was present, but the investigator was standing. In the cross-examination, maybe fidgeted or forgot that. You know about the case. Maybe forgot that, and then what happened? At the end of the day, he was thrown out. Yeah, exactly. So all that he faced to do is that there was no indication that the lawyer was there and it was not signed. And that, I'll give you very practical. This is public document. That's in the case of the Federal Republic of Nigeria versus Munir Gasso. So you can check that out. So it's happening. And I also want to let you know that even aside from that, ICPC have some lawyers from the Legal Aid Council that are domiciled in the commission for people who cannot engage lawyers to sit with them when they are going through the interview processes. And having said that, I don't want to let me now just briefly read what I've prepared, and then I'll be out of this place. It can never be overemphasized that corruption poses a fundamental threat to global security and people's way of life. All over Nigeria now we can't move about freely, and it's just because of the fact that the real thing that brought us together has been destroyed. In Nigeria, it impacts everything from the quality of life, our roads, the health system. When you look at our health system now, ordinarily, I remember when people like me were growing up, that was the primary health centers in localities. There were the general hospitals, which was the secondary health level. There were the teaching hospitals, which were the tertiary. But in these days and age, there is no primary health care anymore. So what should have been secondary has become primary. And we are even having a fast deterioration that what ordinarily we should regard as the tertiary health institutions, the specialist hospital, the national hospital now are fast becoming the primary healthcare centers. So our healthcare system destroyed, educational system destroyed, basic infrastructures are all broken down, internal security completely zero. By Sunday evening again, some videos went viral. Banditry on Kaduna Abuja Road again. They've taken this, they killed this and all that. And that is virtually what we basically hear everywhere. These days, you and I don't want to go anywhere now when there is no possibility of flying. Nobody wants to go by road. Nobody wants to see a stranger and take him in. In those days, our parents would tell us, when you see a stranger, be good to them. Because we may not know he may be an angel. But these days, better be an angel and stay outside there. Because nobody wants to take that risk. And these are basically what we're facing. The protection of our territorial integrity and our collective nationhood. The protection of our territorial integrity and our collective nationhood is seriously threatened. In the modern age, the sophisticated corrupt offenders will take full advantage of the loopholes in cross jurisdictions and induce professionals, gatekeepers, like lawyers, accountants, or corrupt law enforcement officers, computer experts, etc. in their clandestine operations, and to help them launder their corrupt proceeds. As stated by the World Bank in 2004, corruption is the single greatest obstacle to economic and social development. It manifests in the form of bribery, grant corruption, cyber attack, illicit financial flow, money laundering, and other economic crimes. All these are in most cases inextricably linked. The crime of money laundering, understood as hiding, which we understood as hiding or obscuring the source, the ownership, the control, and the movement of assets, could be seen as the last link in a long chain of corrupt acts, as it seeks to lower the chance of detecting stolen funds, as well as breaking the direct link between the kleptocrat and the stolen asset by disguising the ownership. According to the World Bank, illicit financial flow refers to the cross-border movement of capital associated with illegal activities, which may include but not limited to smuggling, trafficking, drugs, outright stealing of the country resources, like crude oil theft, tax evasions, and many more. The Global Financial Integrity Report in January 2019 on IFF to and from developing countries underscored the fact that illicit financial flows and trade misinvoicing, which is accomplished by misstating the value or the volume of an export or import on a custom invoice for the purpose of evading or avoiding value-added tax, custom duty, etc., remain an obstacle to achieving sustainable and equitable growth in the developing country. As a region, sub-Saharan African countries has the highest propensity for trade misinvoicing. During the 10 years, should I stop now or round up? Which one? Okay. All right. Applicable practice in Nigeria. As the foremost anti-corruption agency in Nigeria, the Independent Corrupt Practice and Other Related Offense Commission, ICPC, has the mandate to rid Nigeria of corruption through lawful enforcement and prevention measures. Thus, the Corrupt Practice and Other Related Offences Act 2000 provides in Section 6A basically talks about investigation. In Section 28(1) of the Act, it gives the Commission permission to order anybody to attend before it. These are procedures for our investigations, which we have talked about so much this morning. Chiuke has gone into that, Chinelo has talked about that, and I've also made some clarification. And let me just take Section 44(1). It said that this is the power of the chairman of the commission to require any person to furnish a statement on oath explaining how he was able to own assets linked to him. And this is in a case where you have somebody that is living above his means. And if he fails to satisfactorily explain his ownership of the asset, the commission can recover the asset found or suspected to be proceed or instrumentality of crime through financial investigation of illicit wealth or asset. We have copies of the act here if some of us want to see it. That same section 42 subsection 2 speaks on that too. So on this note, I must say that the ICPC as well as other anti-corruption agencies recognizes the right of personal liberty of persons that are invited to assist in the investigation of a petition as guaranteed by section 35 of the Constitution of the Federal Republic of Nigeria. So in section 42 of the Act, it states purposely the procedures that the commission must follow and the rights of the respondents that must be respected. I do not want, there's also the case of Kenwa versus EFCC, which we have discussed here very extensively now. And I want to say that I don't intend to be more Catholic than the Pope or more Islamic than Prophet Muhammad. So I'll just skip that and then conclude this way. It should be noted that the discourse on illicit financial flow as a means to curb jurisdictional economic crime is gaining international focus more than ever for an including legislative discourse. All hands must be on deck to see that we push this frontier as a way of stopping, tracing, and to recover our illicitly transferred assets. It is therefore a great honor to be part of this discussion this afternoon and to share my thoughts on some of the issues raised. Thank you.
Thank you very much, Mr. Kayode, for your thoughts, which I'm sure we have all enjoyed. I want you to please give him another round of applause. Well, the summary of all that he has said, or one particular area of emphasis in his paper, in his delivery, is the fact that here I am from the ICPC, and we are different from the police. We are well trained, we have our own manual, and we don't follow the mode of police in investigating our cases. Can we give a round of applause if that is correct? It started on a very philosophical note. You know, somebody who is an oppressor today. That's how I take it. That's how I take it. Somebody who is an oppressor today, tomorrow can be the one to be oppressed. I cited the examples. And that is a big lesson for us, particularly those of us claiming to be occupying position. Because the position we occupy today, according to him, he will not remain there forever. So thank you very much for reminding us. And he said so many other things. Well, thank you very much for your contribution. Many of you are lawyers there. Yes, I think that's an advantage. Yes. So, well, all said and done, I think we have had a wonderful session under the topic Judicial Updates and Legislative Developments, Economic and Cyber Crimes, except that we had little about cyber crimes. I thought we were going to have, maybe I will have to wait for Benedict, to get some tips on cyber crimes. All the same, the floor is opened, for questions and contributions. For those of us who are insiders here and those in the virtual world watching us online. So we begin from the in-house. Yes.
Thank you all distinguished panelists for your very insightful remarks. I am expressing concern towards the modus operandi in the investigation. I, on a lighter note, feel a lot of our security agencies have watched too many American films where there's elaborate sting operation and you just raid this place and you just see a pot of gold. That is not, we are seeing a trend where you can be in your hotel room. Whenever I'm in Lagos, I'm so afraid. I'm telling you the truth, because I can just be coming out of the bathroom and lo and behold, an EFCC operative or the relevant security operative will accost me and say we are looking for your boss. Somebody told them, and the hoteliers allow these people, despite the fact that I have a contract with them, into my premises. I want to really bring this to light. And they lay down procedures for investigation. Can you just willy-nilly just say this whole estate is the subject of an investigation, and then what about the harm suffered by the ordinary citizen? Even when it is brought to the attention of the security agencies, they claim they are not aware, and they cannot even as much as apologize for the inconvenience caused and the embarrassment caused to the ordinary citizen. I think we need to really look into this issue. Thank you very much.
Okay. Yes, please. Mike, though.
Well, I just want to make a comment on the ICPC. When I was at the National Institute of Policy and Strategic Studies, I conducted research work on the investigation by ICPC and the FCC. I found out that ICPC, as quiet as they are actually a lot more effective than EFCC. They are not brazen. They are very systematic, and they take their time to do their job. And that's part of the conclusion I came to in that research work. But I've been there recently. There's this famous multi-billion naira FHA house where some people brought a company whose address was in a signboard, some corner piece in America, something in a signboard in America, and millions and millions of dollars were taken away by these people, ostensibly to import prefabricated buildings for an estate in Abuja. My client was the architect who was in charge of this matter. These people had advance payment guarantees from GTB to guarantee the monies, millions of dollars released. But somehow, nothing was imported. millions of dollars were taken away, and they had put it on my client. They said, come, they invited him. But when we got there, to their credit, they did not force us to do any. We provided all the information. So we had, the consultant was very detailed in his notes. He had written the right letters. So they said to us, please, we don't have any problem with you. You will work with us. So now we became their friends, and we supplied information. I think that their practices should be commended to other investigative agencies, so that they can achieve a lot more. Nigeria has been bled so badly by corruption, but those who are charged with investigating, I think the story is different when you go down to Jabi. The attitude, very brazen, Gestapo police style, a lot of threats and all that. But I think that a lot more needs to be done in the professionalism of those who are charged with investigating and using the best practices. For me, I give back to you people, and it will be another day we would draw other conclusions. Thank you.
Yes, at the back here.
Thank you, Mr. Chairman. My name is I.S. Yahaya. My own observation is this. I think that prosecution should come out of an advice, not merely information as our security agents get. They get information, they invite or investigate whatever they do. I am of the view that after their due investigation, it is proper that there be advice to prosecute before persons are charged to court to face trial. And the office to advise, I think, is the office of the Attorney General and Minister of Justice. If that is done, I believe that the prosecutory power of the EFCC, ICPC, police, and the rest of them will not be based on the information they get because you cannot get information, be the one to investigate, and at the same time conclude within you, in-house, and say, okay, we are going to prosecute. Let the prosecution come out of advice from the Ministry of Justice. That is my humble opinion. Thank you.
I hope that will be the last person here.
My name is Louis Umuze, Minister of Justice, Delta State. My question is to the last speaker. Can you please tell us the ICPC's procedure to manage seized properties? Briefly, please.
I'm sure that one arising from the first session we had. It will be interesting to really hear from him. Yes, any from the virtual world? Yes. Okay. So, the lead speaker, do you have any response? Okay. Oh, all right. Sorry.
My name is Anselm Obareze. Please, I want to ask this question to Mr. Kayode. Sir, you people are the law enforcement agents. Why do you people arrest someone before interrogation or investigation? Before investigation, I mean. Because according to what the lead presenter presented this morning, and according to best practices, you have to investigate first, get your evidence before arrest. Thank you.
Thank you, Chairman, for permitting me to answer from me and to sit down. I want to appreciate Mr. Dowdy for talking about the mode of our operation and sealing of an estate. Honestly, if I live in an estate and an estate is sealed up and the peace of that place disrupted, I'll feel really aggrieved. If I drive up my car on the road and I'm stopped and harassed by the police as if I'm a Yahoo boy, I will feel embarrassed. So it's a fact. But like I said earlier during my first opportunity to present, this practice might not be the general practice. And as lawyers, we always say to every general rule, there are exceptions. I want to see this as exception, but it's an unacceptable exception. So it's our responsibility for all of us to jointly cry against it. It has to stop. I have my colleague here. If an operation is going on under me, and you tell me that you want to go for this kind of search, and we want you to prove to me what is the high suspicion you have and the specific place. And I tell people, law is specific. Law enforcement is specific. You cannot just cast the net into the river and look for anybody that it catches. It's not ideal. Law is specific. In those days when we do investigation, we need a document from 2018. We will say bring your back statement from 2016 to the year 2000. These days we don't do that anymore. We tell you the specific one that we need. Because what's the essence of collecting from you documents that we are not going to study, or because we want to give you a decoy? That might be old practices, but law enforcement too is developing every day, and that our operation is getting refined every day. And this particular practice that you say, I see it as an exception, and it's not something that should be encouraged. I want to appreciate my colleague here that just appreciate the processes in ICPC. I'll take the message home, and I'll see it as a nod on the head so that we try to get better. Now, let me briefly respond to Mr. I.S. Yaya, who talks about prosecution should be, ours should be adversary, and we should not be the one to actually investigate. Yes, some people have argued this, but I hope you know that if that is the practice, most of the cases will not end up being prosecuted. That is just what we might have. You even discover that most cases that are of interest to the political authorities always end up in only prosecuting. And so these are likely things that we will go into. We need to bear this in mind. And one of my brothers there talked about ICD procedure or manage its assets. We've come up with a philosophy on our cis assets in ICPC. And the procedure is that we are not undertakers. And by saying we are not undertakers, our policy is that no asset is allowed to die in our hand. When you talk of asset recovery and management, there are 5 stages. The asset identification, asset investigation begin, asset identification next. Then you must be able to trace the specific asset. Then we move on to the asset recovery, which is 2. As the physical recovery, when we signboard or we write on the wall, this property is under investigation by ICPC. Then the legal process of recovery, when we go into the court. And this will result in forfeiture. Forfeiture takes 2 stages. The interim forfeiture, which is the first one, and at which the owner of the property can still show cause and have his property back, and final forfeiture. And I must always even say, even at final forfeiture, it might not be completely final if you still have reasons to contest the asset. And then the asset management stage. I want to believe that your interest is now on the asset management stage. At the asset management stage, like I said earlier, we understand, like, we've been able to classify assets that we recovered. We classify into lands, we classify into building, we classify into businesses, we classify into moving vehicle, we classify into perishable assets like livestock. Of course, the general principle of asset recovery is anything that breach, don't cease. Because you can't maintain it, you can't keep it. So in such cases, we will do bonding. We will bond it to the respondent to be able to produce. And it is something like, if it's tomato or whatever, the law permits us to sell and then keep the money in an escrow account and an interest in the account pending the determination of the case. For vehicle, we can bond the vehicle to the respondent, or we can take the vehicle into custody. In many instances, we take some vehicles into custody. But in recent time, we bond some to the respondent at a value, meaning that the determination of the case. If you either produce this vehicle or produce value worth of this, for businesses, we either bond it to an existing manager in there. But if you believe that the existing manager is not going to be transparent, is not going to be faithful, is not going to be dependable, we make an advert. Very recently, we entered into an MOU with the Nigerian Institution of Estate Valuers and Estate Surveyors and Valuers
for the valuations of our assets and for the management of assets within their jurisdiction, so we can engage a manager who will manage the asset. And that reminds me, when an asset is recovered and it comes to our possession, we take proper valuation of that asset, so that in our book it is carried on with a professional valued figure. We have officers of the Ministry of Works that works with us there and do valuation. Let me crack a joke with one. There was an instance in which a particular respondent voluntarily, through a deed of surrender, surrendered an asset to the commission that in lieu of what you are looking for, please take this asset. And he gave it to us, she gave it to us at a value. And we said, no, before we do that, your valuer says this asset is for 400 million. We got in the professional valuer from outside, value it for us. It was valued at about 180 million. So we say, oh, we can't take this for 400 million. This goes for 180 million. Why do we do that? It's in the public interest to take the lower, as at that instance. And you will be very surprised that within 48 hours, the balance figure, the person carved it out. Meaning that this person will have cheated you and me, entire Nigerians, if we have not done our work professionally. So our asset management culture is to keep the asset in existence, so that you don't throw people into the labor market, so that the country can keep on generating taxes through the company income tax and the personal income tax of the workers, and then everybody is benefiting. I hope I've been able to answer your question. And then the last one say, why do you arrest before investigation? No, what we do is this. Our investigation procedure and principle is bottom up. When a petition comes to us, it goes through a vetting. A unit will vet that petition to know if it's worth investigating or it's within the ICPC mandate or not. If it's not, if it's for the police, we throw to the police. If it's for the EFCC, we throw to the EFCC. If it's for administrative settlement, we said the organization should take care of it. When it is recommended for investigation, it's assigned to an investigation division. That investigation division, the first step is that it's assigned it to an investigation team that must come up with an investigation strategy. The investigation strategy must be able to identify what are the germane allegations here and what's my strategy for investigating. From this point, we move into document retrieval and analysis, document examination. So we examine document. I have a case in which somebody, sorry, Mr. Chairman, I'm dropping your mic now, sir. We have a case that I investigated some time ago, and somebody alleged that a governor collected money for it. What was about that case was this. The then governor of that particular state, on his complimentary card, just took the complimentary card and he wrote a note, the bearer is for me, please assist. And he gave the complimentary card to his girlfriend, who went to a commissioner for works. And the commissioner for works turned a job that was budgeted for direct labor into a contract. Now, this job on the budget template was for 30 million. That was many years ago. But when the girlfriend came, she said she was going to get the job done at 17 million. So she was paid 17 million cash. Now the difference, which is 13 million, we said, Commissioner, where is 13 million? He said, Governor collected from me. Where is the document that the governor used to collect from me? He said, no, he didn't sign anything, he collect cash. You understand me? At that particular time, we did our investigation, we brought the commissioner in. We didn't bring the governor in. Because on what basis will I bring the governor in? Because there's a comment card that said the bearer is from me. Who is a bearer? Anybody could be a bearer. Please assist. What does please assist mean? What kind of assistance? So that is what we do. We do a bottom-up approach in our investigation. We only bring anybody in when there is a reason to bring the person in. And that's our procedure. I hope that answers you, sir.
Note, I have to express my deep appreciation to Chijioke Nwonye, Chinelo Ogbonza, Benedict Taudu, and Adedayo Kayode for making this session very interesting. Thank you very much. I will hand over to the DG from now.
Technical, just to be sure we don't have any contributions online. Well, if in the absence of same, please let us give our panel a resounding round of applause. Please. I know the day is far spent, but we can really show our appreciation. This is a very important topic. Honestly, right from the lead presenter all the way to Chinelo, Benedict, and Mr. Kayode, you can agree with me, we had varying perspective on these best practices on economic crime investigation. This brings us to the end of today's session, and I'm sure lunch, as usual, has been going on discreetly. And if you have not gotten same, I'm sure the conference director will ensure that you get a pack. Tomorrow is the final day, and tomorrow we have only one session, and that session will be starting, because we have enough time, we'll be starting it by 10 a.m. 10 a.m. so that you can relax, rest, and come. You start by 10 a.m. and hopefully before 12 we can finish, so that our brothers who are Muslims can go and say their prayer before they join us for the closing cocktail/party. And tomorrow's session will be talking about violence against persons, and we are looking at protecting the vulnerable persons in our society: children, women, and young persons. And we have different speakers. We have EY Kura SAN, we have Mrs. Azura, we have Hadiza Usman, we have Hajinus Ibega, and Mrs. Chisom. And then we have somebody from NAPT too. So it will be an interesting discussion on how do we protect women and young persons. And I'm sure we have been seeing several reports on the violation of our young persons and vulnerable persons. So thank you very much for today's session. God bless you all, and hopefully you will return with us tomorrow. God bless you. Group photograph, all resource persons, group photograph.
The proclivity for sexual abuse makes the girl a weak sex. Even as the girl child receives all the attention, the importance and place of the boy child in the family and the larger society cannot